Good evening, everyone. Chip Cooper for FTC Guardian and my partner, Alan Cutts. Believe it or not, this is the last hangout in the month of September 2018, meaning that we are closing in on the end of the third quarter of this year,
Wow.
which which is amazing to me. It just seems like it's going by extremely fast. And I guess it is, right? So one thing I'd like to point out, last time we had a hangout, this hurricane, I forgot the name of it, but the big one that really,
Florence.
Florence, that's right, really crunched North Carolina, South Carolina, and some other states in there. And I grew up in eastern North Carolina, and it was really quite depressing to see a lot of the little towns in eastern North Carolina that we used to travel to play high school football and drive through on the way to the Outer Banks for a vacation. There's all underwater, and some of it is still underwater today. So our thoughts and prayers here go out to those people, and I have a real close affinity with them because I grew up in that area. So hopefully everything will get back to normal sooner rather than later. What about you, Alan? What's up with
Yeah,
you?
just on the vein of the hurricane, one of the towns or little towns that Di and I looked at last year and the year before last about moving to is right outside of Myrtle Beach,
Yeah, well,
Conway, which has been underwater, and it was supposed to like hit the crest Monday or Tuesday of this week is when it was supposed to crest, and because they've been underwater since the hurricane. So and what's strange is it's inland. Myrtle Beach itself actually did really well. This is about 20 miles, 15 to 20 miles inland, and it just got
if you're inland along a creek or river, you can be
yeah,
worse off than people right on the coast, depending on elevation. So
yep, yep, yep,
that's where we were here in Northeast Florida last year and the year before. We were very fortunate because we're on higher ground and the beach is right in front of us, and we didn't have any flooding. But people 20 miles inland on rivers and creeks were underwater. So,
yeah, yeah. So anyway, we won't be moving to Conway anytime soon. So
all right. So
let's get
let's
started.
let's get
First, let me have a couple of things. One, if you have a question, make sure you mark the question box down at the bottom. There's a little bubble. Mark it as a question. We have so many people online that if you just keep putting it in the chat box, I don't see it. So make sure you mark it down in the right-hand corner as a question so I'll see it. Also, for everybody who's online already, and I'll hopefully, if I remember, I'll announce it again at the end. We already have the October dates set. If you want to mark your calendar for October the 9th and the 23rd, October the 9th being at 7 p.m. Eastern, and October the 23rd would be at 8 p.m. Eastern. So if you want to mark your calendars for those, we have those dates set. All right, Chip, go ahead.
Okay, we're still with GDPR, and I was talking to Alan before we went live here. We've still got two or three more that we're going to finish up by the year end this year, and that's going to pretty much, if not completely, finish the coverage of GDPR. We want to get coverage of all the major aspects of it, and we're really well into it now with GDPR 8, as you can see on that title slide. And we're going to be covering data mapping and the right to be forgotten. So let's go to the housekeeping announcement you've seen before. Presentation, of course, is for informational purposes only. It is not legal advice, and we're not affiliated with the FTC. And this is the slide that we always show, GDPR, effective this year on May 25. And here is a list. I'm not going to go through the whole list, but this is our list of Hangouts this year. I believe they began sometime in May or sometime close to the effective date, and we tried to cover all of the main topics. And of course, last time we talked about Google Analytics, a very important one because it applies to just about everybody here. And then, of course, this one again, GDPR 8, data mapping and the right to be forgotten. So what in the world is data mapping? When I was at my legal conference in Austin, Texas, actually on the day that GDPR went into effect, of course, May 25th, just happened by coincidence to be, there on the 24th and 25th. And the 25th, of course, is the effective date. And there was a huge panel discussion with all the world's leading experts on GDPR. And of course, the place was loaded. I'm thinking 300 or so attorneys there who do what I do. And so we were all very much interested in their discussion, which went on for about an hour and a half. But one of the terms that they used over and over and over again, and a lot of these were attorneys for big corporations, is where is your data? Where is it? And of course, that's what data mapping is all about. It is intended to answer this very fundamental question: where is your data? Now, in order to get into the weeds of what the GDPR requires in terms of where is your data, data mapping, and the right to be forgotten, the key is Article 30, which deals with the requirement to keep a record of data processing activities. Now, if you look down at the very bottom of the slide at the asterisk, you see there's one at the top of the slide and one at the bottom. The requirement to have a data processing record doesn't apply if you have fewer than 250 employees. I doubt very seriously if anyone on this call has more than 250 employees. But then if you look at this exception or exemption, whichever you choose to use in terms of how you describe it, the exception or exemption applies if you have fewer than 250 employees, unless processing is likely to risk the rights and freedoms of data subjects. That's a little murky. Processing is not occasional, or there are certain special classes of data related to criminal convictions. So the exemption has an exception to it, and it's a little bit vague. So I think you're probably okay if you have a lot fewer employees, but companies that have closer to 250 and above should really pay closer attention to it. And basically the idea is you're supposed to maintain a record of data processing activities, and that includes whether you're a controller or a processor, and make it available if required. And the whole idea of data mapping is that data mapping as a process will help you create this record. So the record requires these things, and I'm not going to go into detail because I think the exemption applies to just about everybody here. But if you go to the next slide, which is here, you see that all of these items here that would be in the data record required. I'm going back to this Article 30 of GDPR. If you go forward again, all of those topics are going to be in these documents, right? You're going to have the controller has contact information that has to be provided on the end of the opt-in forms. And then in the yellow, you see in the privacy policy, all of those items will be covered in the privacy policy. Of course, the contact information is in the DPA and also in the opt-in forms. And then the last one, the description of technical and organizational security measures, would be in your data security policy. So even if you don't have a formal record of data processing activities, the same information required in the record is going to be found in these basic documents, your DPA, and we have an entire Hangout devoted to that, also the privacy policy and the data security policy. These are documents that we have available in the dashboard for members, pro and enterprise members. On the far right-hand column at the very bottom, if you click on the DPA link, the GDPR link, you'll see these documents among the replay videos of our Hangouts relating to GDPR. So if you don't do the record because of the exemption, the same information would be found in these documents. So what is the basic process then for data mapping? Basically, all you're going to be looking at in answering the question is where is your data, is you're going to be looking at the bulleted items, the data items that you contain. What is it? Is it email addresses, actual names, that sort of thing? Number two, the data format. How is it stored? Hard copy, digital, that sort of thing. And then transfer methods would be the third thing. Internally, externally, is it on phones? Is it on laptops? That sort of thing. And that's the last one, where data is stored in your office, in the cloud, third parties such as service providers, that sort of thing. So this is a list of what the data mapping process will discover And this is what you need to be able to do in order to be compliant with GDPR. So, what are the tools that you might use? And let's go back, the tools that you might use in order to take care of this process just discussed. Well, you can go really simple. You can do a spreadsheet, right? If you're not a big company, it's pretty simple to do a spreadsheet. If you are accustomed to spreadsheets, which I'm not, I don't do spreadsheets. I do, the only thing that I do that's similar would be a table in a word processor, such as Microsoft Word, right? Sort of the same thing. You can create a table there and put in the information that was on the prior slide. Or you can go the automated route. And here you're going to probably be using some, instead of, unless you want to create your own, which I doubt that you do, you're going to be purchasing software or access to a SaaS service that will provide the tools for you, right? And here's an example of an automated tool. And you can see here that one of the tools in this toolbox, so to speak, is data mapping and inventory. And let's go back. You can see in the upper left-hand corner, maybe in white at the very left hand of the green header there, One Trust. I have no interest in One Trust. So I'm not recommending necessarily this, but I know that they have a very comprehensive automated tool that really relates to all aspects of GDPR compliance, and certainly the one we're talking about here, which is data mapping and inventory. So another format of the tool or an automated tool might be sort of like a flow chart, which is what you see here, which describes the way data flows through your organization. You collect it and then it goes here or there, it's processed, it's eventually archived somewhere. So this is another handy way to go about the process of data mapping, right? So let's get into the right of erasure, which is GDPR Article 17, also known as the right to be forgotten. So assuming that you've taken care of data mapping and you know where your data is, then if you have the personal data of an EU data subject, someone who is resident in one of the EU countries, these individuals, as indicated in the top bullet here, have the right to have their personal data erased. Generally speaking, there are exclusions to that and there are also exceptions. And this is known as the right to be forgotten. So essentially, a data subject will make a request verbally or in writing. And believe it or not, I've already had 3 clients that have had data subject requests to delete information. And this, of course, happened after the effective date on May 25. So we've actually had 3 clients that have had to deal with this. And you can see there in the 4th bullet, if the request is made verbally or in writing, you got a month to respond to the request. And the right is not absolute. It only applies in certain circumstances. And it is not the only obligation for deletion of personal data. There's also an obligation for data retention, right? So when does the right of erasure apply? When I'll run through this very, very quickly. There's no need to go into great detail here. If the purpose that you collected the information is no longer necessary, then it would apply if requested. If you collect the information on a consent basis, such as the opt-in forms we talked about very early in our series of Hangouts regarding GDPR, when they withdraw their consent, and that's what they're doing when they contact you and say, please delete my information. If they've given consent, they're basically withdrawing it and telling you that they want it deleted. And if you have a legitimate interest, if that doesn't apply anymore, but the one that's highlighted in yellow there, if processing is for direct marketing, you really need to be very, very careful to apply, to comply with the right of erasure. That's obviously very marketing oriented. If you've processed the data you unlawfully, obviously the right of erasure applies. If it's necessary to comply with a legal obligation and you process personal data of a child 18 or under. Now, the most of the questions that I receive as an attorney in the area of this right to be forgotten is the exceptions to this right to be forgotten. And of course, the right to be forgotten is a right that a data subject has to require you to delete the information. So a lot of questions have arisen with me about when is this right? What are the exceptions to this right? And you see the two in yellow are the big ones here that will probably relate to you in most circumstances, I'm thinking. One would be if you have a legal obligation to keep the information, then that prevails over the request by a data subject to delete it. You've got a legal obligation to keep it, you can keep it. And then the bottom one there in yellow, for the establishment, exercise, or defense of legal claims, very closely related to the other one. And if you look in the upper right-hand corner, if you trace those arrows back, the classic examples would be taxi. If you're selling products online or services, you need to retain certain records for the Internal Revenue Service, right? And that would be to comply with a legal obligation. Also, under the CAN-SPAM Act, which governs your use of spam for marketing purposes, your use of email, not spam for marketing purposes, you are required by this statute to maintain an unsubscribe list, also known as a suppression list. The unsubscribed list, of course, was a list of email addresses and names of people who have asked to be unsubscribed. Well, in order to do that and to actually unsubscribe these people, you need to retain the suppression list or the unsubscribed list. So those would be two clear exceptions. You can see the others there: to exercise the right of freedom of expression or information, to carry out a task with the public interest, for archival purposes, scientific research, etc. So as far as you're concerned as members of FTC Guardian, those two that are highlighted in yellow are going to be the ones that you're going to be looking at as exceptions to the data subject's right to have you delete the information in the vast majority of situations. To comply with your legal obligation, you don't have to delete it, and also to establish, exercise, or defend a legal claim. And the two classic examples are IRS records and the unsubscribed list. So what are the takeaways here? We've reached the end of the discussion. Data mapping really answers the question, where is my data? Data mapping is also very useful and helpful regarding the record, assuming it applies to you that you need to keep. Data mapping tools include, very simply, a spreadsheet or a word processing table, or at the top end of the spectrum, maybe software or a SaaS service. The right of erasure or right to not be forgotten only applies in certain circumstances, and it's not absolute. Those two exceptions we talked about just a second ago apply. So here are the tags that I'm going to add tomorrow morning when I upload the replay video: GDPR, right of erasure, right not to be forgotten, data mapping, CAN-SPAM Act, unsubscribed list, suppression list. So that's the end of my presentation. As we're trying to get to the actual end of our discussion on GDPR, we're closing in on it. And by the end of this year, we're entering the fourth quarter, as we just discussed. By the time we get through the fourth quarter, we will have completed GDPR, among some other things, so that we can move on with a real emphasis again on FTC compliance, of course, which is our primary mission here at FTC Guardian. So I'm going to ask Alan, does he have questions?
One question. Yeah, a question from Victoria. Does MailChimp already is MailChimp already doing this for the members? You would really be better off to ask MailChimp than us. I know I use ActiveCampaign, and most of this is taken care of through ActiveCampaign. if I am marketing to EU subjects specifically, then ActiveCampaign takes care of the back end. It's up to me to tick a couple of boxes and take care of the front end, where I would ask, if you're an EU subject, you got to click here or whatever.
Could you elaborate just a little bit on what ActiveCampaign is actually doing for you and us?
Yeah. So ActiveCampaign on the back end, number one, keeps a suppression list. Everybody who unsubscribes, I have a list. I can go there anytime and see a suppression list, download the suppression list, or whatever it is. Anybody who says they've unsubscribed or whatever, I can see it. I can see the IP. I can see the date they unsubscribed, anything else. That's what ActiveCampaign does on their side. On my side, if I want to pick, create using ActiveCampaign, they have a form that, and I don't use many people's forms, whether it's Aweber or ActiveCampaign or whoever. I don't use their forms. I use my own forms. But if you used ActiveCampaign's forms, they have a little box you can tick. Are you going to be collecting names, email addresses from EU subjects? If yes, then you click the little box and it creates a drop down, where people have to click the little box. I would do that myself, but you're better off. And MailChimp is a very large provider, so most likely they are. What you just need to know is where it's at. Like within ActiveCampaign, I know where my suppression list is. As a matter of fact, I can add people to my suppression list. If I get an asshole on our list, I can add him to my suppression list just so they can't do anything. Right. We never send. They can't even opt in. I mean, if we get somebody who's a butt and I can just put them on the suppression list, they can't even opt in, even though they think they do. They don't. So.
Okay. Well, I'd like to make sure everybody that we're not confusing anyone here. If someone, all of us use email services, right? And the email service is supposed to have that little unsubscribe link at the bottom of the email. That's a requirement of canned spam to have that unsubscribe link. Believe it or not, I've actually seen a few lately that I'm trying to unsubscribe to that don't have it. I'm amazed that that's the case. Nevertheless, if somebody unsubscribes, then you have certain requirements under canned spam to make sure that they unsubscribe, they go into a suppression list. But if someone says to you, I'm an EU data subject, I'm unsubscribing, and I also want you to delete everything about me, then you should say, well, you can unsubscribe by clicking on that link, but you're going to go into a suppression list. You're not going to get any more emails from us, but we've got to retain your name and email address in the suppression list. So we have the right.
We have to keep your name and email address so we know not to do this anymore.
That's right. So that's one of the yellow highlighted exceptions there. So if somebody actually requests that, just kindly inform them that you have a legal obligation under U.S. law to maintain a suppression list. So you're not going to delete that, but they're never going to get the emails anymore.
Yeah. Right. Okay. Another question from Christopher is, if we do not sell to anyone in the U.S., do I need to be concerned with GDPR? And Christopher, it sounds like you may be a fairly new member, because we've talked about this a lot. And the reason I say this, because you have another question too, and we'll answer that question as well. Is unless you're marketing to EU subjects, I mean, like marketing to them, you're doing ads to them. Your website maybe has a little option for English and French. You collect money in euros. You're really marketing to EU subjects. We have taken the approach and taken the stance, basically, we are not necessarily concerned about being EU compliant. We want to make sure that we're doing all the right things, but we as FTC Guardian don't market to the EU. Do we have EU customers? Absolutely. Probably about 5% of our total membership are in the EU. We've got probably about 20% that are outside the EU, US, and probably 5% of those are EU subjects. But we never market to them. They joined FTC Guardian because they market to US citizens and they want to be compliant with the Federal Trade Commission. So I don't say you need to be overly concerned. You need to know. The thing is where FTC Guardian is really handy for you is you need to know what you need to know so that you can keep moving on. And that is, do I need to be? Not right now. Do I need to stay in touch with it? Yes. Do I need to know what I need to know? Yes. But I don't have to jump over any big hoops or do anything. I just need to know what I need to know today. Like if I'm going to be marketing to EU subjects, then I better be watching out for the pop-up I put up. And I better say, are you an EU subject? Yes or no? And I better have these type of things. If I'm right. doing this stuff, then I need to be more, I need to think about it a little bit more.
So let me approach the answer from another angle, a different angle from Alan's approach and his answer. The real concern is, do you have an occasional EU person who signs up at an opt-in form, let's say, or become a member or a subscriber or buys something, just an occasional one? The big question is, if it's just an occasional one, and as Alan said, you're not marketing or targeting them in your marketing by EU language, by currency such as euros, or you don't have testimonialists who are French people or German, whatever, then the occasional sign up of an EU person does not bring you in. If you're not targeting or marketing to, the occasional sign up doesn't bring you into regulation by GDPR. You're fine. But even if it's just a few, if you start targeting them then and marketing to them directly, as Alan said, then even just a few dropping in you're going to be regulated. So don't target them. That's the bottom line. Don't advertise to them. Don't have a sales page in one of the languages of the EU. Don't take payment in euros. Don't target. And if you have a few people sign up, you're fine. But as Alan said, sooner or later, if you stay in business for any period of time, you're going to probably move in that direction, because 5 years from now, the whole world is going to be GDPR compliant, probably.
Yeah. Right? We're already seeing it in California for 2020,
yeah.
Right?
But we by the end of this year, we're going to have all of these replay videos up, which give you a complete picture of all the main issues. So even if you're not involved right now in regulation, stay aware, be aware that we've got the materials here, the documents and the videos, and then you can jump in it as you go along. Okay. Yeah. Any other questions?
Yeah, let me finish with Christopher's other question, since he had two of them back to back, and then we'll jump into another one. Guys, if you're asking questions, please mark it as a question. I've just seen a couple more come through with that aren't marked as questions. They're really hard to find with all the chat roll stuff. What are the benefits of being an enterprise member or an agency member of FTC Guardian compared to a standard member? A pro member, a standard pro member, let's just start with a basic member just has access to like 5 different documents, and that's it. It's what I call like a yellow page ad of having a website. If you have that yellow page ad of owning a website where you just have a website so people can see what you sell, see what your services are, then our basic membership will serve you. You do not get access to all the Hangouts, all of our technology that we do, and the 80 other plus documents.
Hangout if you're a basic member.
Yeah, the 80 other plus documents, you don't get any of that. Now, once you become a pro member, then you have the access to the upgraded privacy policy, which gives you access for doing advertising, email collection, blah, 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 all that stuff, as well as the Hangouts. And you also have access to our affiliate program, which is a 1-tier affiliate program. As an enterprise member, and most agencies are enterprise members. As a matter of fact, some of our best affiliates are agencies, because agencies bring in clients, whether they're building their funnels, they're doing their advertising, they're building their websites, or whatever. Call it an agency. If they have a client, 1 or 2 clients, they're an agency and they're bringing in people, then it works, because what they do is they basically give their client the basic membership to get them going, and then we sell them, or we hope to upgrade them eventually to the pro membership, where they can do advertising. And most of our enterprise members sell advertising or sell some sort of agency services for that, so that they need to get them upgraded to being a pro, because they're doing ads for them or doing other stuff. And with the agency, with the enterprise membership, you get a 2-tier affiliate commission, which means the people that you bring in, also you get a 10% override and all that, So you understand that. But just so you know, most enterprise members are hosting companies, agencies, like ad agencies, funnel people who build people's funnels and all that kind of stuff, web developers, hosting companies, coaches, anybody who has a tribe. If you've got a list of customers who are, that's your tribe, that follow you, one that we have, actually a couple of them, it's kind of strange, is we've got one person that I can think of off the top of my head. He specializes in the insurance niche. We're doing a webinar for him in a couple of months in the insurance niche. So he's an enterprise member. So he has people who specialize in that. So he sells our product into the insurance niche. The other one sells in an obscure niche that none of you would think of, and that's of the what's it called? The pregnancy centers, into pregnancy centers, which is a nonprofit organization. So they sell into nonprofit or into pregnancy centers who need our information, because even they need to make sure they're compliant with the Federal Trade Commission, and they help the pregnancy centers, in this case, market their businesses and stuff like that. So it really depends. If it works out for you, then you need to be an enterprise member. So those are the reasons why. Okay, let's see what else we have here. Moving them. Victoria, I'm operating in the belief that every subscriber is an EU subject. She says I am. She doesn't say I will be. I am operating on the belief that every EU subscriber is an EU subject, or will we be covered by the California? Well, if you're operating on the belief that everyone is an EU subject, then you should be covered by California without a problem, I would think. Would you agree?
We're not absolutely sure yet. We're going to be covering the new California statute, which some people refer to as GDPR light. And there have been some changes to it in the last month or so. So early in January 2019, we're going to hopefully be at a steady state where the changes will have been made. And then we're going to present to you the difference between the two, and we'll compare and contrast the basic requirements. So sometime in January, early February, we're going to do that. And we'll update you, big time on that at that time.
And if I remember right, that doesn't actually go into effect until 2020, right?
That is correct.
Okay, so our people have time to.
Yeah, if we do this in January, let's say, which we probably will, either the first or second one, then you basically got a year, because it goes into effect on 2020, January 1. So if in the month of January 2019, we give you the basics that you need, you got a year to deal with it and get up to speed on it.
Yeah, and just so you know, I can imagine this happening, because that's just the way California works, is that we'll be talking about stuff in January of next year. And even before it goes into effect, we'll be making changes to it, because California makes other decisions, just like now.
Statutory changes to it in the last month, because it was rushed through the legislature in California.
Yeah.
And some of the opponents have been negotiating some changes to the statute. So if we had a hangout back when the thing passed a few months ago, we would have had to totally, redo have a makeup.
Yeah.
Because the thing has changed. It's sort of a moving target, so to speak.
Yeah.
So we're going to wait until early January, and get you up to speed then, and then there's pretty much a year there to work through it. But we're going to take care of it at that time.
Yep. And then somebody here says, what if we are getting the majority of our leads through organic Pinterest Instagram, YouTube, and an occasional follower hops into the EU, you're in the same boat. If as long as your website is not, you're not targeting EU subject. Now, for example, if in your Pinterest, Instagram, or YouTube videos, you're speaking to EU subjects, guess what? You're targeting EU subjects. If you're saying we've got a better price for EU for France, or you're targeting those people, then that's targeting, right? I mean, there's no other way to say it. Then you're targeting.
You're speaking French or German in those videos. You're targeting them.
Yeah, you're targeting them, or you're giving them a better discount for whatever that is that you're targeting.
Don't target them, and you're fine.
Yeah, just don't target them, and you'll be okay. And just stay compliant with what we're telling you to stay compliant with, and you'll be okay. But
there's one exception. I had a client a few months ago where, in the introductory call, we were going through this, are you regulated or not? That was sort of the beginning call. And I mentioned this idea of targeting. Do you target? No, we don't target. So I gave the examples of targeting. No, we don't do any of that. We don't target. And I said, well, okay, you're okay. So you're not going to be regulated. But I said, do you have any idea of what percentage, just generally speaking in round numbers, what percentage of your subscribers are from the EU? Oh, we've got a lot of them. Oh, really? And I said, well, roughly what's the percentage? Oh, at least a third to 40% of our subscribers are EU citizens, but we don't target them. And I said, well, now, okay, you don't target them, but there's still an awful lot of them in terms of percentage. So even though you're not targeting with a percentage that high, you might ought to be seriously considering compliance. So that is an exception. But generally speaking, if you're not targeting, that's the key. If you're not targeting, as Alan and I both gave examples to a few minutes ago, you don't have to worry about an occasional sign up or sale.
Yeah.
Unless half of your sales, for some strange reason, despite no targeting, are still going to EU data subjects, then you probably ought to be compliant right now.
Yeah, and we're a good example. FTC Guardian, we don't practice, to the full extent of GDPR. I do the same things we've always done, and that is never target. I just don't target EU. I mean, if somebody happens to get on my list, they get on the list, that's there, but we don't target them.
But okay, so we don't target. You check that off and you're in good shape. But then the follow-up is roughly how many, just generally speaking, are signing up? About 5%.
I mean, total. I mean, again, 20% are probably outside the U.S., 5% are probably GDPR. I mean, EU subjects.
Not 30%.
Oh, gosh, no.
Like this client I was talking about. So
yeah, no, and that's just it. That's just it. I don't concern myself with it.
Don't worry about it. But if you're not targeting, but all of a sudden that percentage is growing 25, 30, 35, 40%, then you probably need to.
And I'll tell you, I mean, some of our members may be JV Zoo type people. I don't know. If you're selling on JV Zoo, Warrior Forum, I don't know as much about Warrior Forum, but I do know JV Zoo. If you're selling on things like JV Zoo, then I would be a little bit concerned. Not that you're marketing to EU subjects. JV Zoo has a lot of EU subjects that buy products on it.
Yeah, well, that falls into that second question. Oh, you're not targeting, but how many actually are buying or signing up? If it's a relatively high number, 25, 30, 35, 40%, then you really ought to consider.
Yeah, if you're selling digital stuff and it's like on a JV Zoo or something like that, then I'd start to be a little concerned because that audience is so big, and I know that probably at least 40% of it is European based. I mean, they've got to be 30+% has got to be European based. because they're buying stuff cheap, right? It's that type of audience. So I would just think about it. I would look at your audience and think about it. So anyway, we've gone. It's 40 something minutes. So
any other questions? That's
no,
it.
I don't see anything. Nope, I don't see anything.
All right, guys. Again, we're just about finished with the third quarter of 2018. I keep saying it because it's hard to believe, but it's true.
Oh, I want to bring up something. Mark, because Puffery will be the first one, right?
Puffery update. And the reason is Puffery is so critical because ad claims carry with them the responsibility of substantiation of the claim that you make. And sometimes that's hard to do, right? So one of the totally safe ways to go about advertising without having to worry about substantiation, totally unregulated, totally safe, is Puffery. And you need to understand exactly where the line is between Puffery and an ad claim. And in this, and we've had, if you go to the search function and key in Puffery, you're going to see, I believe, 2 or possibly 3 prior Hangouts that deal partially or totally with Puffery. But what we're going to do the first of this next month, October, is we're going to drill down and we're going to have some examples that are just on one side and some on the other that'll give you, I think, a lot of really good information about where to draw that line between the two, because drawing that line is really critically important.
If you don't want to be regulated, if you want to say, I would love to use testimonials, I love to use ad claims, but I don't have the substantiation to use some of these things, then Puffery is your way to go. So we're going to show you on October the 9th. Chip will show you, talk to you about it, and I'll follow up with you because I understand Puffery now and love it. Actually, it's, if you know how to use it, then you can use it to your benefit without having to show ad claims. And
however, Alan understands it. He's a marketing guy, and he needs to know: are you making an ad claim or are you doing Puffery? But the case that I'm going to be talking about has a series of ad claims, some of which were found to be Puffery and some not. And it's really close.
Yeah.
In fact, so the fact that they're all sort of close, I think, is going to be very helpful to really help you zero in on what Puffery is and what it is not. Very valuable.
Excellent. Okay. That's it.
All right. Good night, everybody. We'll see you next month.
Good night.
Night.